Thank you all for coming to the 2018 Watershed Congress. My name is Aaron Stumpowitz. I am the senior attorney at the Delaware Riverkeeper Network, and my presentation here today is titled Natural Gas Pipelines, a Technical, Environmental, and Legal Primer. Just to give you a little bit of background on myself, I started with the Delaware Riverkeeper back in August of 2011 and have primarily focused on natural gas infrastructure issues and litigation, and specifically on pipelines. And that is what this presentation is going to be focusing on. Specifically, we're gonna go through a very brief explanation of the different components that make up natural gas pipeline systems, why it's important to make sure that these systems are appropriately regulated. And then the second half of the presentation is going to be more focused on an update on recently decided case law, pending litigation, and potential future litigation that folks might be interested in the space of natural gas pipelines, particularly in the Northeast here. So with that, I'll get started. So natural gas pipeline delivery systems are unlike delivery systems for other energy, other types of energy such as oil and coal. You need pipelines to distribute natural gas in order to get it to where it needs to go. And these pipelines range from small home delivery pipelines to large-scale interstate transmission lines. And I'm going to explain a little bit more about which pipelines are regulated by what entities to start out, to give everybody a little bit more perspective. The way that I look at the different pipelines in a pipeline natural gas delivery system is sort of to look at it like a tree. So if you picture a tree in your head, the gathering lines, what are known as gathering lines, are the roots of the tree. Gathering lines essentially are the ones that collect natural gas directly from the source, directly from the gas well pads themselves. The transmission lines, which are these larger scale, larger diameter pipelines, you can think of them as the trunk and major branches of the tree. And then the distribution lines, which are the much smaller pipelines that take the natural gas to each individual home or business, those are more like the small, very small branches and leaves of the tree. So that's one way of looking at and visualizing natural gas transportation delivery systems. So with regard to gathering lines, the natural gas industry is currently constructing an expansive web of these type of lines outside of the Delaware River Basin here, but in the central part of the state and the western part of the state, you're seeing sort of a proliferation of gathering lines and almost like a spider web formation if you're to look at particularly if you're going to look at Pennsylvania and look down from like a bird's eye view. Typically, gathering lines are 4 to 18 inches in diameter. Some are as large as 24 inches, but mostly are smaller scale, operating at 150 to 1,000 pounds per square inch. The construction of this particular network of pipelines poses a unique threat in that they aren't regulated by any federal entity or frankly any state entity either. Particularly when you're looking at a more holistic approach to impacts to watersheds as a whole, no one's really looking at those gathering lines in a holistic type view. Another component piece of natural gas delivery systems are obviously also the compressor stations. And compressor stations are located approximately every 50 to 60 miles along different pipeline systems. And the idea is that they boost the pressure of the natural gas in the system to get the gas from one place to another. Typically, the gas moves inside these pipeline systems at roughly 30 miles an hour or so, and usually involve thousands and thousands of horsepower to get the gas moving. They can be loud, they can be noisy, there can be flaring at the stations. they're typically can be rather disruptive when newly constructed. Now, the transmission lines is really going to be the focus of the litigation that I'm going to talk about later. So this is the trunk of the tree, right? Transmission lines, in particular interstate transmission lines, are the really large-scale 24 to 42-inch diameter pipelines that require at least the industry reports require wide rights of way and significant disturbance of ground cover in order to put these transmission lines in. They move large amounts of gas. The pressures in these systems are quite significant, getting up to 1,500 pounds per square inch, typically a little bit lower than that, but they can go as high as that. And these transmission lines can fail for a variety of reasons, whether it's internal corrosion or material failures, welding problems, or outside sort of third-party impacts that can be responsible for some problems with those type of lines. Now, lastly, the distribution lines, the small little branches to the leaves, they're typically very small, 2 inches to 10 inches in diameter, very low pressures. Those aren't really going to be the focus of this presentation, but it's just good to know that that is the last component piece of these delivery systems. So you might ask why we care about pipeline projects and the impacts of construction and operation activity for pipelines. Well, every natural gas well pad will need a pipeline connected to it. And in Pennsylvania, if looking at Pennsylvania, we're talking about a state that has 83,000 miles of streams, which is the highest density of stream miles per unit of land in the country. So when you have a lot of pipelines, that means you're crossing a lot of streams, you're crossing a lot of wetlands, you're crossing a lot of water bodies, and the construction methods for going across these different water bodies can result in significant impacts to those water bodies. And there are other presenters at the Watershed Congress who can detail sort of the scientific data that has been collected showing what type of impacts can result from these pipelines. But needless to say, you can have everything from deforestation to introduction of native species, stormwater runoff, soil compaction, impacts to benthic invertebrates where stream crossings occur, all sorts of different impacts. Changing the values and functions of wetlands as a result of the construction and operation activity. All these things are related to pipeline construction. And when looking at just the Delaware River Basin itself, and the Delaware River Basin is the Delaware River and its tributaries that feed it. And that's the Delaware Riverkeeper Network. That is sort of what we consider sort of our jurisdiction, at least from a legal perspective, is the Delaware River Basin. If we're just looking at the Delaware River Basin, which extends from the southern tier of New York down through Pennsylvania and New Jersey down into Delaware, we've seen over the last 6 or 7 years, we have at least 25 different large-scale pipeline projects crisscrossing the Delaware River Basin in order to transport natural gas from the Marcellus Shale region out, whether that gas goes abroad or goes to commercial or home users. It goes to a variety of different places, but we've seen really a proliferation in pipeline projects. So with regard to these large-scale natural gas pipeline projects, we have a variety of federal, state, and local entities that are involved in the permitting and regulation of those pipeline projects. And one of the lead federal agency for the purpose of interstate natural gas pipeline projects is the Federal Energy Regulatory Commission, or FERC. And they are the lead for the purposes of the environmental review of these projects and ultimately providing a certificate that can be used in courts to allow pipeline companies to exercise eminent domain and or access to property for the pipeline company. They are the main focus for a lot of litigation as well. But there are many other agencies also involved that pipeline projects cannot move forward absent them providing different permits or approvals. And just again to provide Pennsylvania as an example, the Pennsylvania Department of Environmental Protection is responsible for providing a number of different permits and certifications for pipeline projects, without which the pipeline project cannot move forward. One of those is a Clean Water Act Section 401 water quality certificate that PADEP needs to provide that. There are substantive component parts of the Section 401 water quality certification that provide the substance of that certification. Those are the Chapter 105 Water Obstruction and Encroachment Permit, the Chapter 102 Erosion and Sediment Control Permit, and what is known as a NIPDES PAG 10 permit. And that's a permit related to the hydrostatic discharge of hydrostatic testing waters and withdrawal and discharge of waters related to that activity. All those permits are required by the Clean Water Act, and without which a project cannot move forward. Another important agency is the Delaware River Basin Commission. The Delaware River Basin Commission is an interstate, is essentially the consummation of an interstate compact of the basin states, representatives of the basin states. And when a pipeline project is proposed that triggers review by the Delaware River Basin Commission, the pipeline project applicant is required to submit what is called a docket, or a draft docket, an application to the DRBC, which the DRBC reviews and then either approves the docket or denies the docket. There are various triggering mechanisms for DRBC review, one of which is whether the project crosses what are known as comprehensive plan areas, or recreational comprehensive plan areas, which are all codified in the DRBC's regulations. So there are certain areas of the Delaware River Basin where if a project crosses through it, that automatically triggers review. Another triggering mechanism is whether the pipeline project involves a significant disturbance, what's called a significant disturbance of ground cover affecting water resources. And the DRBC has defined a significant disturbance as being a project that impacts at least 25 acres of wetlands. That would also trigger the need for a DRBC docket. A third triggering mechanism is the withdrawal or discharge of a certain amount of water, of gallons per day for hydrostatic testing purposes. Any one of those three triggering mechanisms, and there are others, may result in the DRBC exercising its jurisdiction and requiring a permit or requiring a docket. So those are sort of the federal, at the federal level, some of the permits that are involved. There are others that are involved. For example, a component of the erosion and sediment control permit issued by the Pennsylvania Department of Environmental Protection is actually reviewed by local county conservation districts, and they're the ones that actually do the substantive review and approval of those permits. But by and large, when we're talking about FERC jurisdictional projects, so in other words, interstate transmission pipelines, the federal government, or the Federal Energy Regulatory Commission, their review preempts the field. So if you have a local municipality who doesn't want a pipeline running through or next to a school or a hospital, that local township or municipality has no authority to say, no, you can't put your pipeline there. FERC ultimately decides where the pipeline is going to be sited. That sort of regulatory structure is sort of thrown out the window when we're talking about FERC jurisdictional pipelines. That may come into play, the local zoning may come into play in the context of other pipelines, whether it's a gathering line or perhaps a distribution line, but for the purposes of this presentation today, again, we're focusing more on transmission pipelines because that's the most growth we've seen is in those type of pipelines. And in that context, FERC is really the main focus. So what I'm going to do is focus now we sort of understand the basics of what are the component parts of a natural gas delivery system. I'm going to focus on some of the litigation involving these different permits and approvals that I've briefly discussed here. One of the most recent cases and most significant cases that was decided came out in August of this year out of the DC Circuit Court of Appeals. And that case is called Sierra Club et al. Versus FERC. And in that case, the Sierra Club filed a lawsuit alleging various National Environmental Policy Act deficiencies in FERC's analysis of the Sable Trail pipeline, which is a pipeline located in the southeast U.S., rather large pipeline. And the court agreed with the Sierra Club on climate change related impacts and ruled that FERC must quantify the emissions of the related to the pipeline based on an EPA model. This was significant because it was one of the first times that a court decided that the Federal Energy Regulatory Commission needed to look at the sort of downstream end use of the gas that's going through the system when doing their environmental review of a project. In this case, Sierra Club said that because FERC is aware that a substantial portion of the natural gas is going to be used in various natural gas power plants, that FERC needed to quantify how much greenhouse gas emissions are emitted as a result of those activities and determine whether or not that can result in a significant impact to the environment. FERC has previously, in many other cases, refused to do that sort of analysis. And here the court said, stopped them in their tracks and stated that you need to take into account these sort of impacts. It's a rather significant case. There's some uncertainty as to how far the holding in that case can be expanded or whether it's going to be narrowed by future litigation, but it is a really important case that we're going to see lots of future litigation help shape. Another important case that is more local involved the Millennium Pipeline project. The Millennium Pipeline Company. As a case called Millennium Pipeline Company versus Seggos, the New York State Department of Environmental Conservation. That case was also decided in 2017, also in the DC Circuit. And there, Millennium filed a lawsuit in the DC Circuit seeking to force the New York State Department of Environmental Conservation to act on or find that it had waived Millennium's request for a Section 401 water quality certificate. And there the court ultimately dismissed Millennium's petition and determined that Millennium had to first request that FERC decide whether New York had waived its right to issue the water quality certificate. So the primary issue before FERC as a result of this case is when did the time start by which New York State had to start reviewing a project and make a decision. New York, the Clean Water Act requires that New York make a decision within 1 year. So the question is, when did that 1 year triggering mechanism start? And so the court said, we're not the ones that are supposed to decide this. We're going to kick it down to the Federal Energy Regulatory Commission. They're going to decide when the clock started. Since that, so the case was thrown out, but in a way remanded to the Federal Energy Regulatory Commission. This case was important because it laid the groundwork for Millennium requesting that FERC find that New York DEC waived its right to issue the water quality certificate because Millennium alleges that New York DEC waited longer than 1 year to issue this water quality certificate. The Federal Energy Regulatory Commission ended up agreeing with Millennium Pipeline Company in that case, saying that that indeed New York DEC had waived their right to issue this certificate because they waited longer than a year. New York has since filed a rehearing request, and we're likely to see some litigation about finalizing how that 1 year time period starts. We're likely going to see that sometime in 2018. FERC usually takes a while to make a final decision on rehearing requests, so it's going to take a little while for that case to be finalized. Another really important case is the Constitution Pipeline Company versus the New York State Department of Environmental Conservation. That case was also in the Second Circuit Court of Appeals, also decided last year. And there, Constitution filed a lawsuit for review of the New York State's denial of a water quality certificate pursuant to the Section 401 of the Clean Water Act. In this case, New York decided that the construction activities proposed and the application materials offered by Constitution Pipeline Company for this large, over 100-mile pipeline were not sufficient and, in fact, violated New York State's water quality standards. It was a surprising ruling from New York DEC, and one of the first times that I'm aware of that a state essentially blocked a pipeline project, exercised its authority and blocked a pipeline project that had been already approved by the Federal Energy Regulatory Commission. So this sort of had New York State butting heads with the Federal Energy Regulatory Commission. And it really ended up having sort of tragic consequences for people in Pennsylvania. When FERC authorized the Constitution Pipeline, they did so prior to New York deciding that they were going to issue a water quality certificate. But after the state of Pennsylvania provided a water quality certificate for that project. So what Constitution did is they assumed that they were going to get their water quality certificate from New York, and so they started to clear the right-of-way in Pennsylvania. And so they cleared trees, they did all sorts of earth disturbance type activities, only to later find that their project was blocked by the state of New York. So you have this large right-of-way in Pennsylvania that was cleared for no reason. And it was really had some really unfortunate results for landowners, because we had people who had maple syrup farms and trees that were used, in commercial production of maple syrup that were cut, destroyed, and the family's no longer able to continue that family-owned business because for a pipeline project that will likely never be constructed. Constitution Pipeline Company has since filed a writ of certiorari at the Supreme Court of the United States, asking for the Supreme Court of the United States to review whether or not it is lawful for states to block federally approved pipeline projects, considering that there is no circuit split on this issue, and considering that typically the Supreme Court grants somewhere between 1% and 2% of the cases that are filed before them. I think it is highly unlikely that the court even takes up this case. And for all intents and purposes, the Constitution Pipeline is largely dead in the water as of right now. But we'll see. We'll see how that litigation plays out. Another sort of landmark case was one that we were involved with. Delaware Riverkeeper versus the Federal Energy Regulatory Commission. Again, a court out of the DC Circuit Court of Appeals that was decided in 2014. In that case, we argued that FERC improperly segmented its environmental review of 4 separate pipeline projects, which were actually, in reality, one large pipeline. These various projects, essentially the argument was that FERC sort of put on blinders and looked at each individual project and the impacts of each individual project rather than looking at them as a whole. it was the first time that the DC Circuit or any circuit court had ruled that the Federal Energy Regulatory Commission had violated the National Environmental Policy Act, and therefore, to a certain extent, actually laid the groundwork for the Sierra Club case that came out this year. I think there has been a lot of litigation at the DC Circuit against FERC as a result of our success, that first successful case we brought about 3.5 years ago, that was decided about 3.5 years ago. And FERC has come under increasing scrutiny as a result of that case. Unfortunately, we're seeing that the Federal Energy Regulatory Commission hasn't really learned their lesson with regard to segmenting pipeline projects. In fact, we have seen Tennessee Gas Pipeline, the pipeline company that was at issue in that original case, we've seen them now constructing an additional project in the same way that they constructed the one that was found to be unlawful in our case, using the same exact methods. There are, I think, at least 3 separate projects that have been proposed and/or are already under construction that will complete a third continuous pipeline alongside the first 2. That are being segmented. And those project names are the Orion Pipeline Project, the Triad Expansion Project, and the Susquehanna West Project. So if you look at those projects, each one of them sort of leapfrog each other, and gaps in that one continuous line continue to be filled in by newly proposed projects. Eventually, the plan, as admitted by Tennessee, is to have a third continuous pipeline. And unfortunately, FERC has again segmented its review of these individual projects rather than looking at doing a sort of programmatic environmental review of the projects as a whole and looking at what the impacts would be across the entire right-of-way for that pipeline. There likely will be litigation involving those projects, perhaps by us, perhaps by others, in the not-so-distant future, focusing on this concept of illegal segmentation. Another case that is, so those cases are ones that have been decided within the last couple of years that are important cases and ones that sort of laid the groundwork for future litigation or pending or existing litigation. Now I'm going to focus on some pending litigation that is before the courts right now that we may see that we're likely going to see opinions come out of the courts that's going to further shape the way in which FERC and the states deal with these pipeline projects. And one of them is a case filed by the Delaware Riverkeeper, again, against the Federal Regulatory Energy Commission. But this suit that I'm going to talk about here is a little different in that it's not focusing on any one specific project. Rather, this lawsuit focuses on due process violations that result from the way in which FERC reviews and approves pipeline projects and the way in which FERC is funded. Specifically, the Federal Energy Regulatory Commission, it derives all of its funding from the industries that from the regulated industry. So in other words, the pipeline companies that FERC regulates are the ones supplying FERC with, essentially supplying FERC with the funds for their budget. This, we believe, creates a perverse incentive for FERC to approve additional pipeline projects because there's an incentive there that the more pipeline projects you have, the more diverse your funding base is, and therefore FERC has sort of a institutional interest in approving projects. And this institutional interest is sort of manifested itself in a number of ways, including FERC's 100% approval rate for natural gas pipeline projects that have come before the commission for a vote. So we've never seen a natural gas pipeline project, specifically a natural gas pipeline project, that was specifically denied by the Federal Energy Regulatory Commission. Indeed, the only projects that we're aware of that have been denied by the Commission are projects that didn't have or were unable to show sufficient contractual support for the gas that would be moving from one place to another, or being used in a compressor station, or being used at a LNG plant. So in other words, FERC had no assurance that they'd be getting paid because there were no contracts. So that leads to FERC being, we believe, a biased adjudicator of these applications for these pipeline projects. So that is really the primary issue before the court. But another really significant issue is whether or not the Pennsylvania Environmental Rights Amendment confers a property or liberty interest sufficient to sustain a due process claim. In normal cases that either the Delaware Riverkeeper brings or other individuals or entities bring, to show standing, to bring your case, one of the first elements you need to show to have a successful case, to show standing, you just need to show that you have a recreational or aesthetic interest that will be impacted by the proposed activity. But for a due process claim, it's a little different. You need to show that you have a life, liberty, or property interest at stake. So as a very important component of this case is we needed to show that one of our members or the organization as a whole had a property or liberty interest that would be impacted by FERC's bias in their adjudications. And one way we chose to do this is point to the Pennsylvania Environmental Rights Amendment, which provides the right to a healthy environment, a clean air and clean water. This was a novel legal argument that has never been brought before. And it turns out that right after briefing in this case finished, the Hawaii Supreme Court agreed that the Hawaii Constitution, that an environmental provision in the Hawaii Constitution does provide a liberty or property interest sufficient to sustain a due process claim. So we're hopeful that the DC Circuit will follow this state court and agree with us that the Pennsylvania Environmental Rights Amendment, which is actually more specific and stronger than the one in Hawaii, does the same thing. So even if we were to lose the case in the context of FERC being biased, but were to win the case in the context of the liberty or property interest conferred by the Environmental Rights Amendment, it would still be a very significant success because it would pave the way for other types of litigation in the future. Now, another major issue in that case is the deprivation of due process as the result of FERC's use of tolling orders. So in order to challenge a certificate, an approval of FERC of a pipeline, a party needs to first be an intervener and then submit what is called a rehearing request. And a rehearing request essentially identifies all the issues that the aggrieved party believes that the Federal Energy Regulatory Commission failed to appropriately address in the order or otherwise, and would be preserved for appeal. Typically, so after the rehearing request is submitted, FERC is required to, within 30 days, act on that rehearing request. And as an aggrieved party, you can't go to court until FERC has acted on that rehearing request. And so what FERC does is they act on the rehearing request by issuing what is called a tolling order, saying that we act on this rehearing request by virtue of the fact that we grant rehearing insofar as that we need more time to consider the rehearing request. So essentially it tolls that 30-day period to indefinitely. So what happens typically is, and this has happened in numerous cases that DRN has been involved in, is FERC will toll the rehearing request, and then while the rehearing request is tolled, issue letter orders approving all sorts of different types of construction activity while the aggrieved party, in this case us, have to sit on our hands waiting for FERC to act. And so by the time we get into court, a lot of times significant portions of the pipeline project are already completed or are well underway, trees have been cleared, that sort of thing. So our argument is that is an abuse and a deprivation of due process because it prevents any party from going to court to challenge the certificate. This is also important because as soon as a project applicant gets FERC's certificate, they can walk into any federal district court and bring any landowner into court and exercise eminent domain over that landowner, despite the fact that the certificate may be legally flawed. Unfortunately, the certificate can't get challenged until the rehearing requests are decided upon. So in other words, project applicants can take a potentially legally defective certificate into court, get access to these properties, condemn these properties, or otherwise take the property via these eminent domain proceedings, all based on a faulty certificate that may be reversed or rescinded as a result of litigation. But the system is a bit rigged so that FERC allows these things, allows those eminent domain actions to move forward by the virtue of the fact that they're issuing these tolling orders. So that is another major claim of our case and another major way in which we believe FERC is violating due process. And again, that issue has never been decided on specifically by any court, particularly in the context of pipelines and the Natural Gas Act. The briefing in that case has been completed, and oral argument is scheduled for March 22nd, 2018 in Washington, D.C. So to the extent anybody has any interest in seeing how oral argument goes, they can go to the D.C. Circuit Court of Appeals on Pennsylvania Avenue in Washington, D.C., go up to the courtroom and watch to the extent that they're interested. Also, video of the oral argument is also posted online. That's true for all circuit courts. So to the extent you're interested in the oral arguments that were involved in any of the cases that I'm talking about today, because I believe all of them have been circuit court cases, you can go on to the circuit court websites and actually pull up the oral argument to see how the judges were questioning the various attorneys and get a better feel for the facts, the salient facts of those cases. An additional case that we're involved with is Delaware Riverkeeper versus the Pennsylvania Department of Environmental Protection. This is a Third Circuit Court of Appeals case, docket number 173299. And in this case, we challenged Pennsylvania Department's issuance of a NIPD's PAG 10 permit for the Atlantic Sunrise pipeline project. And NIPD's PAG 10 permit is the permit used and we briefly talked about this earlier, for approving the discharge or withdrawal of hydrostatic testing for pipelines. So in other words, when you put a pipeline, when you're building a pipeline, you need to test to make sure the welds are good and there's no leaks, there's no pressure loss. And so instead of doing that with natural gas, they do it with water. And so that's sort of what this permit regulates, is the withdrawal and discharge of the water that's used to test these pipelines. And the argument that we make it can be broken down to a simple hypothetical. And it is, if, let's say, you're a landowner and you have a stream running in your backyard, and a pipeline company wants to use that water to hydrostatically test its pipeline. So what they do is they can withdraw 100,000 gallons per month or discharge 100,000 gallons per month of water or whatever fluid comes out of the pipeline into that stream. And you as the landowner are unaware that that activity, that permit has been applied for, what's in the permit, the scope of the activities. You don't know anything or have any notice. You don't have any way to engage with the Pennsylvania Department of Environmental Protection until after the permit is issued. And we believe that that is that reality violates the public participation rights as conferred and identified in various provisions of the Clean Water Act. We believe that you as a landowner have the right to engage with PADEP, and in fact landowners are the ones best positioned to provide useful feedback to PADEP regarding activities that are happening in their backyard. But by cutting those voices out, that's not good government decision making, nor is it what is demanded by the Clean Water Act. So briefing in this case will be complete as of March 1st. Oral argument has not been set, but will be forthcoming, I believe, shortly. In a companion case that was argued several months ago, the Third Circuit has already expressed significant concerns and skepticism over this type of permitting regime, even going as far at one point at the oral argument in that case as to saying how could that type of permitting regime be anything but arbitrary and capricious. So we are hopeful that we're going to get some good change out of this case so that to further protect landowners and to further allow potentially impacted individuals or organizations to have a voice in these type of projects. In a separate case that we've brought against the New York State Department of Environmental Conservation and the Second Circuit Court of Appeals, we've brought essentially an identical challenge. The docket number for that case is 173895, and this case again involves a NPDES permit issued for a pipeline project. In this case, it is the Millennium Eastern System Upgrade Project that we believe again does not the New York DEC did not provide the appropriate public participation opportunities based on the exact same legal claims as I was describing that is pending before the Third Circuit. We're hopeful that if the Third Circuit comes out in our favor, we'll be able to use that instantly and present that as strong, persuasive case law that hopefully the Second Circuit will also agree with. And so those protections would be extended not only to Pennsylvania residents, but would be extended to New York. And to the extent we're successful in those cases, we'd be looking at filing actions in other states to do the same. So those are some cases to look out for down the line, at least that we're involved with, that are currently pending before various different courts. So now I'm just going to quickly highlight a few potential upcoming future litigation that we could be seeing coming down the pike rather quickly. And in that context, I'm going to talk a little bit about the Penneast pipeline project, which has been the subject of, which has been a hotly debated subject, and a pipeline project that has garnered a significant amount of interest, not only from impacted landowners, but people from around the Delaware River Basin in general. So the Penneast pipeline project is a large-scale pipeline project that starts up near Wilkes-Barre, runs southeast, crossing a little small portion of Bucks County, going across the Delaware River right around there, and then into New Jersey. It's over a 100-mile long pipeline project. It's big. It's not co-located along an existing pipeline, but rather it's a greenfields pipeline. It's proposed to use various existing rights of ways, but there's a lot of greenfield construction involved with it. The Federal Energy Regulatory Commission recently approved this project and issued a certificate about a month ago. And a number of parties have already issued rehearing requests. We were the very first ones. We filed our rehearing request within days of the FERC certificate being issued, but many other groups have followed us, including, and not insubstantially, the New Jersey Department of Environmental Protection, the New Jersey Rate Council, the Lower Saucon Township, and various other groups, individuals, and even elected officials have all filed rehearing requests opposing the way in which FERC reviewed and approved that project. It's notable that the Penneast Pipeline project was a project that one of the very few pipeline projects where I've seen the commissioner split on the vote. there was a dissenting vote, which is very rare in the context of FERC, and the dissenting commissioner expressed serious reservations about whether this project was actually needed. So there's some opposition not only within the community but within the agency itself of this project. I think that it is an inevitability that we're going to see a lot of litigation to the extent this project is allowed to proceed. Importantly, the New Jersey Department of Environmental Protection has actually already rejected a number of Clean Water Act permits for this project. So despite the fact that FERC has given it the okay, New Jersey has rejected a number of applications, and there is a significant portion of landowners in New Jersey that have refused to allow Penneast onto their property. So Penneast now has been forced to go into court and gain access to these properties via eminent domain. So we're going to see a lot of litigation in that space as well. There are a number of permits on the Pennsylvania state side, including the Chapter 105 permit, the Chapter 102 permit, the NIPDES permits that have not yet been issued for the project and that are also very likely to be subject to litigation. We have submitted comments on many of those permits. The Army Corps of Engineers has not issued what is called a 404 dredge and fill permit. We have submitted comments on that. That may be subject to litigation. So there's a lot of moving pieces with regard to Penneast, and there's going to be a lot of, at least my suspicion is there's going to be a lot of litigation involved. So that sort of sums up some recent case law that's come down. There's a PowerPoint presentation associated with my talk here today where everything should be laid out as far as the case law identification. So to the extent you're interested, you can look at the opinions in these various cases, or you can follow the pending litigation via the different dockets that I've identified as well, docket numbers that I've identified. And also to the extent that folks have questions, I know this is a video presentation, but we at DRN would be happy to do our very best to answer questions that you may have. Thank you for your time and your attention, and thank you for coming to the 2018 Watershed Congress.